thrilled that you made time to be a part of this. We have a great turnout, and by looking at the registration, it's an international turnout, which is exciting, something that we cannot do under ordinary circumstances, to have an alumni event and have people from all corners of the world in attendance. So this is one of the upsides of the new technology that we're all getting to know. Well, I hope that you are all well and that your families are well. I wanted to maybe just very briefly describe the outline for the program, the plan that we have, and then get to the main event. So I'll just give a very brief update on things at the law school, but keep it brief in order to get to the main program, which is a panel discussion featuring 3 of our faculty experts addressing different legal dimensions of the reopening of society and of commerce. Now, we're here in New Orleans. We're heading to what we're calling phase 2 here on Saturday of the reopening from the shutdown. And that means that most businesses here will be back in operation at 50% capacity. So restaurants are getting back into swing, and so it's happening. Of course, also on this day, I saw in the news that there were reports that in some other parts of the country, there are some spikes in numbers of transmission connected with reopening in other places that are a little farther ahead of us. So obviously it's a timely and important question and presents a bundle of legal issues relating to different dimensions of this. And so in our main event today, we're just going to seize on a few of those dimensions, though there are obviously many more. But looking at the implications of new technology that have implications for potential bias and discrimination and invasion of privacy, and then also looking at implications for reopening in the world of sports and in maritime shipping and commerce, as just 3 examples drawing on our faculty expertise. I'll just, by a very brief way of update on the law school, just share that we have, I know this has been for all of us, an intensely challenging period of time over the past several months. And in many ways, of course, the challenges are becoming more intense. We, of course, have been dealing with the pandemic and the topics that we'll be discussing head on today. But then, of course, also in more recent weeks, have been dealing with the crisis involving racism and equal justice. And I will say that as challenging as these events have been, and I hope that I know they've been hard on everyone in their own ways. But for me, it really has affirmed the importance of our mission, speaking of the mission of lawyers in society, but also of legal education and of preparing the next generations of lawyers to lead and to confront head-on these most challenging issues in our society. So it's, in many ways, has really been sort of renewed for many of us a sense of purpose and mission in addressing these challenges. I'll say very quickly that we have done, responding to the pandemic at the law school, we, of course, along with the rest of the university and I'm sure all of you in wherever you are, had adapted quickly to the new remote learning environment and working environment in March. And I think we did really impressively well, really almost candidly surprisingly well. And I was so proud of the way both our faculty and students really rallied to the occasion. And that meant not only in the classroom, the virtual classroom, and really engaging fully with that, but also beyond. And so I just mentioned that the class of 2020 that just graduated set a new milestone, a new record for pro bono service. That graduating class recorded 24,000 hours of pro bono service a number of those hours coming during the pandemic, addressing challenges faced by vulnerable populations in the pandemic. We've also are very excited to be rolling out, doing a major expansion of our clinical program at the law school. We have effectively 3 new clinics coming online this summer: a First Amendment clinic, an immigration rights clinic, and really a collaboration between our domestic violence and criminal justice clinics called the Women's Prison Project, that is focused on criminal justice reform for women who have been incarcerated for reasons of domestic violence, being a history of victimization by domestic partners. And those 3, that major expansion of our clinical program, which we're very proud of at Tulane, is of course very timely, both to address urgent needs in the community. And our brand new First Amendment clinic, in its first 2 weeks of operation, has already been serving as a resource for First Amendment rights connected with protests in New Orleans in recent days, but also providing practical skills training to our students, given the increasing importance of providing that training while they're still in school and before they graduate and go on to serve clients and communities. So I might stop there, just because I don't want to take more time from the panel, so I will jump straight to that, and we'll introduce my 3 colleagues in sort of sequence, and I've asked each of them to share maybe 3 or 4 minutes up front individually about the topics, drawing on their expertise. And then we're going to open it up for a dialogue among the whole panel and to take your questions by chat. So while you're hearing the speakers, I encourage you, if you do have questions, feel free to enter them in chat here. And then at the end, I'll be pleased to pose those to the speakers. So our first speaker for the panel is Gabe Feldman. Gabe we're very proud at Tulane Law School to have both the first and still the premier program in sports law in the country. And Gabe directs that sports law program here. He joined our faculty in 2005, and he holds an impressive and daunting and dizzying array of titles here on campus. Not only is he the director of our sports law program, and has taken it to new heights. He's one of the leading, really the leading voice in the country on sports law. You've undoubtedly seen him quoted 1,000 times in national media and beyond. But he's also the associate provost for NCAA compliance. He's the co-founder and co-director of the Tulane Center for Sport. And we were thrilled to appoint him, and once we're able to get back into the building, we'll celebrate with a proper investiture his appointment to the country's first dedicated endowed professorship in sports law, the Sherrod Garner Professorship of Sports Law. So, Gabe, thank you so much for joining us.
Thanks, Dave. Thanks for the introduction, and hello, everybody. I want to apologize right off the bat for the weird lighting that you're seeing. My light in my office just went out, so one of the many pleasures of trying to do these things online through Zoom. But let me jump right in, because I want to give everybody else on the call a chance to speak, and then hopefully take some questions and engage in a conversation. And I want to just mention just the breadth of issues that are facing the sports industry right now, and obviously every industry in the country and throughout the world. But some things that people may not realize are happening, and the issues that are being talked about, and from issues big and issues small, from the highest of the pro levels down to youth sports and high school sports. And the range of legal issues, and again, I'll just highlight a couple to give you a sense of what's going on at the college level. And I'm sure we'll talk about this more throughout the session today. The idea, and the long-standing idea, that our college athletes are student athletes. and that education is their primary focus. And there's been a lot of criticism of that idea, but as colleges are trying to figure out whether they're going to be starting online or in person or some combination of the two, there's a question of how college athletics fits in there. And there was a lot of discussion early on when California school system announced that they would be coming back online, that everybody assumed that meant there would be no football, college football in California. And then if you looked at the specific details, they said, well, there would be exceptions to students that can be on campus, those that would need to be on campus and have access to facilities, including nursing students, lab classes, and the like. And people very quickly started including football players in that conversation. And it's led to a debate, not only from the legal side, but from a moral, philosophical, and every other side you can think of, about what is the role of college athletics? Why are we having college athletics? And why are we putting these athletes at risk? And if you think back to 3.5 months ago, the question about football was, how do we make this contact, this collision sport safer? And how do we deal with all the lawsuits that are happening from former players? And there's an irony, or whatever word you want to use, of the issues about trying to make football safer, trying to limit some of the contact, to now looking at a return to play where there will be a lot of non-contact football practices. And it raises an issue that I think every industry is dealing with right now, is what can we learn from these last 3 months and how to reshape our business and maybe make things more efficient. And in a lot of ways, college sports may look very different in the future than they have in the past, not just in the peak of the pandemic or dealing with social distancing issues, but just as the schools figure out there are maybe better, more efficient ways to do things. And we've already seen schools cutting sports. And so there are going to be a lot of legal issues around that, and Title IX issues. Just jumping very quickly to the pro side. Most of the pro sports that have gotten the headlines are governed by collective bargaining agreements. And the issue of when they will restart, that's a negotiation between the players and the owners. There is no negotiation at the college level because there is no union representing the players. And looking at how much the players are going to get paid, what their cuts are going to be, looking at whether a particular league has a force majeure clause in their collective bargaining agreement or not. The NBA does, the WNBA does not. It impacts the leverage, it impacts when they're going to start, how much they're going to get paid, what type of cuts they're getting. To the very granular issues that, for one example, in baseball, where they're still having trouble reaching an agreement between the players and the owners and trying to figure out some of the health and safety issues, that one of the details they're talking about, as small as this may seem, but there are hundreds of this, is that every pitcher is going to need their own personal rosin bag, so that they reduce the risk of infection and transmission of COVID. And every industry obviously is dealing with their own issues along those lines, but these are all collectively bargained issues, and so there's a lot for them to work through. And then the last point I'll mention, just in terms of the scope of the issue, in terms of return to play for sports, we think about the professional athletes, a relatively small number of people. There were 460,000 college athletes who participated last year, and there are about 8 million kids who participate in high school sports. And for every issue that exists at the pro and college level, those issues are infinitely more complex at the high school level because of the resources and the lack of resources and the different resources. So we think about putting together best practices or standing operating procedures to move forward. What may work for a larger or well-resourced school is not going to work for a smaller school that barely has the funding to have an athletic trainer on the sideline, much less to put in place all these complex protocols that are being discussed. So there are ways to go, obviously, until we figure out what the different rules will be, but colleges have already announced that football players can return for voluntary practice. And the National Federation of High Schools has announced that June 15th, practice can start for football and other sports. So a lot of questions still to be answered, and obviously a lot more will arise, but look forward to the conversation and the discussion tonight. So thanks.
Thank you so much, Gabe. That was terrific. Our next speaker is Martin Davies. Martin is In addition to having the world's leading program of sports law, we're also very proud to have, hands down, the world's leading program in admiralty law at Tulane. And Martin Davies is the director of the Tulane Maritime Law Center. He joined our faculty in the year 2000, so 20 years ago. And he's also the Admiralty Law Institute professor of law and a world-renowned expert in all aspects of the maritime industry and admiralty law. So Martin, thanks so much for joining us.
All right, it's my pleasure, Dave. I guess the first thing to say about reopening and the shipping business is that with the exception of cruise ships, it hasn't shut down. That reopening for the shipping business is really an issue of returning to the levels of demand that were there before the virus started having an impact, because international trade has not stopped. It's obviously decreased dramatically, but with the exception of cruise ships, ships are still coming and going out there and have not stopped doing so. Now, the virus has had a different impact on different types of ships, as I'll try and explain in a moment. But the shipping business has always had to take a long-term view of demand, which is cyclical in all kinds of business that they're engaged in. And this is obviously a very new problem of a greater kind, but something that they're accustomed to dealing with sort of ups and downs in demand for their business. The one issue that is common to all kinds of ships at the moment, and that is a real major problem right now, is something that might not be apparent to everybody at first sight, and that's crew changeovers. Ships regularly change the crew who are on board, and in order for a crew changeover to occur, the crew that's presently on the ship has to get off the ship and then fly home. And the crew that's going to come on the ship has to fly to where the ship is and get on board. Now that sounds like a really sort of simple, straightforward operation, but at the moment it isn't. There's a major bottleneck with crew changeovers at the moment, which is having a significant impact on all kinds of ships. Several UN bodies, the International Maritime Organization, the International Labour Organization, have described it as an international humanitarian crisis, actually, because they estimate that about 200,000 crew members are presently stranded on ships, unable to get off. And the problems are quite simple at one level. The crew members have to have visas. Many consulates around the world that issue visas are closed. Crew members have to be able to fly to and from where they need to be. It's estimated that about 300,000 crew members need to make an international flight every month. That's very difficult at the moment. And so crew changeovers are the major bottleneck at the moment that's affecting all kinds of shipping. And this is something that can only be fixed at a national level. There's a lot of international conventions that affect shipping, but designating mariners as essential workers or providing some means for them to get to and either on or off a ship are things that are happening at national level. Hong Kong has done it, Singapore has done it, Canada just issued new visa regulations, procedures for mariners today. But it's happening at a different pace in different countries around the world. And so that's a very pressing problem right now that's affecting shipping. But otherwise, what's happening in all different kinds of shipping is different levels of projection for the return of demand. Now, container shipping, which is what brings most manufactured goods in international trade, the International Association of Ports and Harbors issued a report just a couple of days ago about 170 ports in 90 different countries. And it suggested that container trade is down about 25% from where it was before the virus. Now that sounds like a lot, but in March, it was down 45% from where it had been before the virus. So already container trade is picking up. Now for oil tankers, it's a very different position. And as I said before, this is really me illustrating the fact that for different types of ships, there are different problems. For oil tankers, the oil price is so low at the moment that oil tankers are simply not carrying cargoes from one country to another. They're being used at the moment for storage. The oil market is in a position at the moment that economists call contango. It's actually been in super contango. And what contango is when the futures price is dramatically higher than the spot price. Now, without getting into too much of the economics, because I'm not an economist, but what this means is that it makes economic sense to buy oil now when it's very cheap, and to store it so that you can sell it when the demand increases. And for the oil business, they're presently expecting demand to begin to spike in December or January. So that's just two examples of how the shipping business has always got to have a view to the future. And to give you another example, and then I'm going to have to stop because we need to sort of have time for questions and discussion. But the country of Qatar is the world's largest producer of liquid natural gas. And Qatar has just put in an order with shipyards in Korea for 100 LNG carriers at a cost of $20 billion. Now, why do I mention this? Well, it takes many years to build a ship. And then once the ship is built, its normal working life is figured to be about 15 years. And so if you're in the business of operating ships, you are necessarily projecting many years into the future. And so the shipping business is not concerned with reopening, but simply how to deal with the pace of demand picking up again. And so it's different for different types of ship, is, I guess, the simple summary that I would make.
Great, thank you so much, Martin. Obviously, we all remember the cruise ships being some of the first to take us into this shutdown, and now fascinating to see how we'll come out of it. Last, I'm delighted to introduce my colleague, Kristin Johnson. We were thrilled to recruit Kristin to Tulane 2 years ago, and she's one of the leading experts in the country on corporate law and the regulation on financial markets. But in recent times, she has turned her focus and really emerged as one of the most thoughtful scholars addressing the social and legal implications of artificial intelligence and other new forms of technology in a variety of spheres, both for financial markets and the business world, but also for other reaches of society. And her work and insight is really much in demand around the country, both in terms in scholarly circles, which is constantly on the, at least when travel was more feasible, on the circuit at leading law schools around the country, but and beyond, but also in business and the press, the media that have looked to her for her expertise. So, Kristin, we're thrilled to have you address some of the implications that you see with the use of technology to address the pandemic. Thanks, Kristin.
Thank you so much, Dave. What a wonderful and warm introduction. I would like to actually just echo some of the things that Gabe and Martin shared in their presentation, and maybe to put the final, sort of the quick comments I'll offer on technology into context. I'd like to show you a little bit of the effects of the coronavirus by the numbers. And I'll just talk about two sets of numbers, one in the health space, which is with respect to the state of our national health and the human capital or human resources that will ultimately return to work and facilitate production in our society. And then I'll say a little bit about the broader macroeconomic implications of the coronavirus. And then I'll close with a few reflections on, as Dean Meyer explained, one or two of the technologies that may be implemented, a few legal implications of those technologies, and then some reflections broadly on some legal and ethical questions that we face for the first time in many instances in our society. So if you'll pass to the first slide, please. Just setting the stage with an actual picture of the numbers. The slide you have before you is sourced by the European CDC and reflects through June 11th on a rolling 3-day average the daily confirmed COVID deaths in various countries in the world. And if you're watching the news carefully and following this, as most of us are, on a daily basis, you would know that today the coronavirus took the headlines back again on most national press, print press, online press, and news media, indicating that in the US we've surpassed the 2 million case mark. There are more than 2 million confirmed coronavirus cases in the United States. The evidence, early evidence indicates that there are declines in states where there were a lot of sort of proactive measures taken earlier on, Michigan, New York, Washington State, and Illinois, and that cases are rising in Arizona, Arkansas, California, Florida, North Carolina, Texas, and Utah. But possibly even more interesting for us regionally, Alabama marked sort of a record number of corona cases confirmed today, and that was part of the press, a 93% increase in the total number of cases in the state prior to today. So this is just to sort of signal to you that we're really still dealing with, in an ongoing way, a crisis, a pandemic of global proportion that we've never seen before. So I think part and parcel of talking about how the law and policy will address these questions may require acknowledging that we are not completely certain about a number of matters, and that all of our reflections, even once we finalize regulation, are at best an estimation of how best to protect society and to facilitate commerce. Next slide, please. So thinking about the size and impact of the coronavirus on our society in the context of the economy, I offer just a very quick picture, which really probably makes the point without my describing the data behind this particular picture. So in this particular picture, what you can see is that since 2008, we haven't seen sort of economic times as difficult as we're seeing today. In fact, in the press today, the coverage describing the economy is recognizing that the economy is in a recession globally, and that we might experience a period of prolonged economic decline that has not been seen since the Great Depression. Despite a better than expected jobs report last week, the Federal Reserve projects that jobless rates will be in excess of 9% even by the end of the year, and will be as high as 6.5% for the better part of the beginning of next year. The US Labor Department reported that consumer prices fell in May for the third month in a row, but that is largely a result of a variety of factors, and that excludes volatile food and energy prices that Martin just alluded to a moment ago. In fact, yesterday in the Wall Street Journal, in an article titled "Fastest Rising Food Prices in Decades," the authors described food makers designing value packs and supermarkets restoring promotions like coupons to offset the economic disruption brought on by the coronavirus. If we look at it in terms of consumer needs and consumer demand, consumer debt has hit a record $14.3 trillion, an amount never before seen in the global or the national economy. This is $1.6 trillion higher than the record set in the middle of the financial crisis. Debt that's surging is both corporate debt, government debt, and individual household debt. Total domestic non-financial debt jumped 11.7% to $55.9 trillion. The index that you're looking at is the Weekly Economic Index, and it provides a signal of the state of the US economy based on data available at a daily or weekly frequency. It incorporates labor market production and consumer behavior. essentially, what I'm positing is that when we look at the global economic factors, we recognize that we are in unprecedented times. And in the midst of these unprecedented times, we can imagine a significant amount of shifting in a number of areas of the law, including employment law, tort law, or tort liability, privacy, insurance, contract law, and real estate. I'll talk about a couple of these areas for a moment in the next minute or so, and then I will pass the baton to our able moderator, because I'm sure that a number of you have questions. And also, it would be virtually impossible for us to successfully talk in great detail about the various areas that we can imagine will be impacted by the deep changes in the health of our nation and the human resources that perform functions and provide and produce resources, and the economy. So what might reopening mean for businesses? As Dean Meyer mentioned at the outset of the discussion, when we think about reopening businesses in this particular environment, you would have noted on the very first slide that I had pictures of workers wearing masks showing up at, we could imagine, Tyson food plant or Smithfield's production of food or meat factories. We could easily also imagine that cover slide had depicted pictures of Walmart greeters in the front of the Walmart store or cashiers at your local grocery store. What kinds of very specific legal questions arise as employers invite their employees back to work? And how might we think through mitigating the transmission of the virus in this particular context? Well, the CDC has outlined, and epidemiologists have long adopted, a three-prong attack for these kinds of questions: test, trace, and isolate. Test individuals to determine whether or not they have the virus. Once we've identified those who are coronavirus or COVID-19 positive, we would trace their contact with other individuals and then isolate them to prevent transmission of the virus. Well, this is exceptionally complicated in our highly intimate society, and particularly in our intimate community here in New Orleans. It's really hard to imagine scenarios in which we are not closely in contact. But just to talk just for a moment about some of the measures, compliance measures that employers may have to undertake. I described in a previous webinar the necessity for employers to, in context, organize workspaces differently or take the temperatures of their employees, and the notion that the EEOC has modified longstanding policy to permit employers to undertake these measures. In fact, we can imagine employers being required to establish guidelines that ensure the distance among or between workers, and to provide something like PPE or remote workspaces to make the workplace less likely to lead to transmission and more amenable for employees, customers, and clients. This concept of figuring out who might be coronavirus positive and who might not be, and tracing them, could easily be accomplished through artificial intelligence. And in a previous seminar, I described that in great detail. Now I just want to highlight some of the legal questions beyond contact tracing that might implicate artificial intelligence. In the Q&A, we can talk about specifically how. So I can imagine some conversation about how to deal with or address concerns around corporate bankruptcies, financial disclosures for corporations, corporate debt facilities, real estate, the contractual provisions for commercial and residential leases. We can imagine that there could be implications in the supply chain and production and inventories, all of which may be improved by the introduction of artificial intelligence. Introducing artificial intelligence, however, raises a number of questions, especially in the workplace, because it may lead to surveillance. And the surveillance, while intended to mitigate the transmission of the virus and to restore the economy to its full strength, may also lead to workers' privacy being eroded in this moment in a way that we may never effectively restore in the future. So I'm happy to talk lots about a variety of ways that we can imagine the integration of AI or artificial intelligence or technology in solving these problems or complying with regulations related to the coronavirus, or to talk more broadly about the macroeconomic implications of the virus generally.
Thank you so much, Kristin, that was really wonderful, and there's so much ground to cover here in a short space of time. But you all did a wonderful job of sort of teeing up the range of, at least a partial range of the issues. What we're going to do now is I want to encourage sort of cross conversation among the faculty panelists, and I'll present some of the questions that have come in through the chat and before the program. But want to encourage you just to keep this as spontaneous, and so feel free to jump in at any point. But I thought I would tee up a question really for all three of you, just to get the conversation going, that was raised in the chat just a little while ago from Bill Benditson in Boston. Great to have you with us, Bill. And he posed the question, I think specifically for Professor Feldman, about the question of potential liability of teams or leagues, I suppose, or colleges or universities, if athletes participating in sports were to contract the virus. Of course, we've seen headlines at the University of Alabama and elsewhere about football training and cases. But really the question is not unique to sports, I suppose. It's the same could be asked of cruise lines or of other businesses, or for Kristin. So maybe Gabe, if I could just start with you, but then ask each of the Kristin and Martin to share their perspective as well.
Sure, and I'll try to give a sort of general but also sports specific answer, and then turn it over to Martin and Kristin. And good to see you, William. I think William, by the way, is one of the rare sports and maritime students. So he was in Martin's office and my office a lot, so it's good to see you, William. In terms of the liability, the issues are very different in some respects at the pro level versus the college level and the youth level, because the pro level, again, most team sports covered by collective bargaining, and the remedy for most injury suffered by football players or basketball players is covered in the labor agreement. And those are typically exclusive remedies. So that would be likely handled by collective bargaining, to the extent that it's not, either because it's an individual sport that has no union or collective bargaining agreement, or it's at the college level. Then I think it's a very similar issue to other non-sports businesses in terms of standard of care and whatever protocols are put in place, and trying to follow the best medical guidance for reopening and ensuring that you meet those standards, which again, I think is such a challenge at the high school level because of resource differences, and the standard of care might be difficult to meet for some of those schools that don't have the same resources. The other two issues I'll just mention, for not only for sports leagues, you can think about the analogy to Broadway or movie theaters. It's not only the athletes, but it's the customers. And what is the liability for having 80,000 people entering a stadium? And you can say, we'll sell only tickets to every other seat, but how do you get them in and how do you get them out? And then how do you get them to the facilities and everything else? And how do you do that in a way that's safe, but also doesn't make it into a 15-hour experience to go see a 3-hour game? And then lastly, I'll just mention that we'll see how this all plays out, but there seems to me to be a really difficult causation issue if you're a plaintiff who catches COVID. That how are you possibly able to prove that you got this while you were at work, even if you can say 10 other people at my office have it or on my team have it? So that's not a sports specific issue, but that's an issue that is going to have to be dealt with in this litigation. Sorry, last point is I know that there is discussion in terms of just waivers that employees or athletes will have to sign, and whether those waivers will hold up, and the conversation that happens a lot of, if we are going to expect these businesses to reopen, do we want to provide them some immunity from these lawsuits? Otherwise, they may not be able to reopen, just because the cost of insurance and the protections they'll have to put in place would be so large that it just wouldn't be economically feasible. So I'll stop there and turn it over to my colleagues.
Thanks, Gabe. Martin, you want to go?
If I could go next. This is a question that I've been asked a lot by journalists lately, because there are already lots of lawsuits about cruise ships. And in the United States, I think most of the litigation is going to be about cruise ships because most crew members are not Americans. So to the extent that we're talking about US law, we're going to be talking about cruise ship cases. And I think Gabe put his finger on it just a moment ago. It's going to be very difficult to prove if someone contracts the virus, that they contracted it, A, on the ship, and B, because of a failure on the ship's part to enforce social distancing guidelines or whatever. So the standard of care in relation to cruise ships is relatively easy. It is a question of reasonable care, but what does reasonable care require? And I think an interesting aspect of these cases is what did reasonable care require at the time that cruises were still happening? Because at that time, it was not widely known, well, it's still not completely known how the virus spreads. And there are issues like non-symptomatic carriers able to spread it. Well, how can you protect against that? There are lots of really difficult questions. One thing that I will mention in the context of cruise lines, a lot of the actions that have been brought are class actions. And it's very common for a cruise ship passenger ticket to have a waiver of class action provision in it. And so all of these plaintiffs in the class action, the passenger suit class actions, have in their ticket promised that they're not going to, they've waived their right to participate in class actions. Now, obviously, that contractual provision might not be enforceable, but those courts that have considered it before the virus happened have all held that those waiver of class action provisions in passenger tickets are enforceable. And I think that that will have an impact on the dynamics of how that litigation plays out in the cruise ship context.
I would just add really quickly that in the broader economy, there are obviously many examples that follow sports and maritime, sort of our thoughtfulness about how each of those sectors are organized. I'd add just the tiny tidbit that OSHA, the Occupational Safe and Health Act of 1970, has a general duty for employers to provide sort of safe conditions for employees. I would further sort of comment to Martin's point that airlines and other common carriers would be similarly situated to sort of what he's described. And I would sort of quibble with Gabe and suggest he's never been to a Dallas Cowboys game because it is a 15-hour event. So I think that your thoughts about timing must relate to a different team or a different sport. But
well, then it would become a 30-hour event.
A 30-hour.
So it would go from 15 to 30.
They might not object. But I think I just contribute a bit here to the conversation by looking at one of the comments in chat. So one of the comments in chat asks whether employers could require employees to receive a vaccine if such a vaccine is developed and the FDA blesses the vaccine. And this is a very interesting question because, you know, in the context of education, at least K-12 education, we've nationally had a fairly robust debate about the extent to which parents would be required to vaccinate children for common, in the sense of historically common or frequently occurring diseases and the extent to which the likelihood of those measles, mumps, et cetera, might recur in our communities. So there are brewing questions, I would say. The vaccine question is an excellent example of a brewing question that we don't yet have clarity about in terms of what could be required. I would also suggest that there are really interesting questions about what conversations are happening with lawmakers regarding this waiver or granting employers some type of protection against liability, and whether or not that ever fully materializes into something that is actually effectively adopted and implemented. And perhaps going back to the earliest part of my comments, which industries that would apply to, right? So could we imagine a universe where in some context you are required to be vaccinated or carry an immunity passport indicating that you've had the virus and you have the antibodies or something like that, right? and then whether or not your employer could require you to demonstrate that. As much as we could imagine in some contexts it being very helpful, the cashier at the grocery store or the barista at Starbucks, for example, how would we distinguish among the variety of types of employment and who might be left out of that, or how might that impact certain groups disproportionately?
That's great. Thank you all very much for that. And of course, just building off of Beneficiary's question in the chat about the potential legal authority of employers to require the vaccine. Of course, there are also related issues, I suppose, with employers' ability or universities and colleges' ability to mandate the use of tracking technology to facilitate contact tracing, like these new phone apps that facilitate that. I don't know, Kristin, I think you've done some thinking about those issues.
I have. So I think this is a great question that may, in some ways, grow out of one of the points that Gabe made, in fact, and the extent to which we might think about who could be obligated to either demonstrate this, I describe this as an immunity passport, demonstrate that they are immune or have had a vaccine by testing, right? Testing, tracing, isolating, right? So testing first to determine if you have the antibodies, if you've already had the virus, or in the event that there's a vaccine, an immunity passport, those two things working together to demonstrate that you're able to participate in society without any fear of transmission. The contact tracing app, presumably, at least the most popular version of the contact tracing app that Dean Meyer and I are talking about, would work off Bluetooth technology. Essentially, there is Bluetooth technology in most smartphones, and the technology also exists in any number of other devices that essentially can find one another on, let's call it a system whereby they are pinging, right, to discover other Bluetooth devices that are within proximity. And to Gabe's point also about where you may have contracted the virus, there may come to be a mechanism whereby we can begin to narrow down the likelihood of where you've contracted the virus based on this contact tracing technology, which would tell us all of the people that you've been in contact with or were in proximity to over a period of time. Most of the contact tracing apps are running for essentially about 30 days of data, and they would signal, for example, if all of us were in a room in this moment, that Dean Meyer, Gabe, Martin, and I were in the room together, if we were together for a fixed period of time, maybe 10 to 15 minutes, and then we separate. So to the extent you want to begin to narrow the ability to determine who might be transmitting the virus, the contact tracing app can assist with that. But it wouldn't be proof in the form, for example, that we were talking about earlier, that could be used in employer liability context. And there are lots of concerns. To my final point earlier in the discussion, there are lots of concerns about the privacy implications of surveilling employees through that mechanism. In the event that the phone itself that you're using is the employer's property, you may have no control over whether or not a contact tracing app is downloaded onto the phone or other device. If it's your own phone, you may have little or no control over what other information the contact tracing app scrapes from your phone and records in some repository that may later be reproduced for other purposes. The presumption is that it would not be reproduced for other purposes and that appropriate guardrails could be put on, but there are no guarantees at this point that would certainly be true. And to a conversation we had just ahead of the webinar, Martin mentioned cybersecurity concerns. So there are cybersecurity concerns with this contact tracing app and a number of other technology-based interventions that we've become tremendously dependent upon during the coronavirus pandemic. Mm-hmm.
Thank you so much, Kristin. There are a couple of related questions, I think, at least loosely related questions for Professor Davies that I see here. And one of them coming from Muna El-Marzuki from Qatar. So now a law professor in Qatar, and so delighted to have you join us. And so she asks for Martin whether the pandemic might be a reason to exempt carriers from liability for cargo loss, damage, or delay. And then a further question was posed about what you see as the most significant legal roadblocks to resumption of global supply chains. So if you have thoughts about either of those, Martin.
Yeah, I've actually been giving some advice about cases like this. I think that in legal terms, in terms of liability for damage or much more likely liability for delay, it's not actually the pandemic that's going to be the issue. It's going to be the fact that what's delaying the movement of cargo is government restrictions on what cargoes can be moved into or out of a port. Many ports around the world have restricted the movement of cargoes to essential goods. And if your goods are not essential goods, then you can't get them moved across the border between the ship and the port, or the port and the ship. And government restrictions on the movement of cargo are very much something that has always been regarded as something that exempts the carrier from liability. There's a ridiculous old phrase that's very familiar to all maritime lawyers, which is still used. I've got no idea why this expression is still used, but the expression that's used is restraint of princes. There aren't very many princes around anymore, and if there are, they're not restraining the movement of cargo. But this sounds to me like it would be a restraint of princes defense. And so I doubt that there will be liability for delay in the movement of cargo for that reason.
Terrific, thank you very much. And Gabe, a question for you about that's obviously hugely significant in the world of sports. I imagine both professional and collegiate sports, about sort of the finance model of sports in the current environment, given the loss of ticket revenue, and whether how can that be made up with TV or other broadcasting revenue, and what could that lead to a massive shift in collegiate sports programs, given the budget implications?
Yeah, thanks. And it's a really good question, and particularly on the college level, there's a lot of discussion going on right now about recalibrating the economics of college sports. And every time there's a discussion about possibly providing more compensation to college athletes, the question that's always asked is, where is the money going to come from? And if we do pay the athletes, then we're going to have to cut sports. And the Olympic sports, the rowing, the sailing, the lacrosse, those are the ones that are going to get cut. And then we're going to lose the broad-based opportunities for college athletics. And that issue has come up again in terms of lost revenue from ticket sales, which no matter what happens in terms of return to play, we are going to assume that there will at least be limitations on how many fans can attend games, and perhaps how many fans are willing to attend games. Although I took an informal survey in late March, so right in the height of everything, and said if the NFL started that day and they opened up Lambeau Field in Green Bay to fans, how many tickets would they sell? And there was almost unanimous answer that they would sell out, even in the height of the pandemic, that people love their sport so much and are willing to risk going to the games. But putting that aside, in terms of the lost revenue, there are already schools, as I mentioned, that have started to cut sports. And there is debate about whether they are cutting because of COVID or they were looking for an excuse to cut. And now they can cut because of COVID and use that as cover. Either way, I think that question of where is the revenue going to come from, whether it's going to the college athletes or they're losing it because of ticket revenue, I think we all know, at least in part, where some of that revenue can come from. And if you look at the massive facilities that are spent, and you look the money that's spent on these facilities, and my guess is that most college athletic programs can do without a waterfall or a miniature golf course in their practice facility. And some of these schools are building miniature golf courses and waterfalls in their practice facilities. And I think this is going to force us to figure out a better model, economic model for college sports, and shift some of the money away from those facilities and from coaching salaries. And these are going to force hard choices. but it's going to also provide an opportunity to make those choices that we haven't been able to do or had the will to do in the past. So I think some benefit could come out of that we are going to see a reallocation, recalibration, and better aligning college sports with the academic mission. And then from the pro context, it's a good question. There are certainly revenue opportunities for leagues to grow, and about 60 to 70% of their revenue, depending on the league, comes from television to begin with. So ticket sales are a relatively small amount of it, but they are all looking for new revenue sources. And one of those new revenue sources is going to be sports gambling. And the sports gambling has become legalized in more states. You're going to see the leagues try to get it, or you've already seen leagues try to get a piece of it. So the last thing I'll note is it's that revenue question makes for some very difficult and uncomfortable debates about reopening and restarting college football, because the question is, why are we in a rush to restart college football? Probably not, as much as I love college football, it's probably not because we think it's essential to the college mission. We're reopening it and trying to reopen it because it's essential to the financial model of a lot of these universities. And again, I'm as big of a fan of college sports as anyone, but it does make it challenging for athletic directors, university presidents, coaches, and everybody else to justify rushing football back when we're not rushing our other students back to campus. So it's a balance every industry has to draw, and this just happens to be a much more high profile industry than others.
And Dave, if I could just say really quickly that Gabe's comments really bring to the fore one of the questions in chat, and something I had in my notes to mention. So far, we've been focused on really who ought to be the first group or wave of employees brought back to work in the economy, and essential workers is easily one of the phrases that springs to mind. I think I just like to highlight and underscore that often those essential workers are among the most vulnerable populations, and they include disproportionately people of color, low-income wage workers. And as we talk about the policies and technologies that will be used to govern and inform our decisions moving forward, I think it's especially important to acknowledge that that these workers have, in many instances, continued to work through the height of the pandemic, and they are among the least paid, least well protected in terms of actual access to health insurance and all kinds of other questions. As we sort of think through these issues, I think it's imperative. It is an opportunity, as Gabe was saying at the end of his comment, it's an opportunity to reflect on some of the most important service providers in our communities, on our campuses, in our buildings, and acknowledge that in some real ways.
Thank you very much, Kristin, and I so appreciate you making that point. And I know that we're really running out of time here in the program, but it really opens the door to really important questions that have been flagged in several of the questions to chat as well, which is highlighting the tensions that exist between sort of pressures for public health and the economy, whether that's sports or in other aspects of the economy on the one hand, and really given the implications of the different demographic sort of impact of the virus on both older, according to age and according to race, and those are worthy, I should say, of a follow-up conversation because they're enormously important. And so seeing that our time is at an end, I just want to thank you all so much for being part of this conversation. Thank, of course, my colleagues, Kristin, Martin, and Gabe, for this really fascinating discussion, and thank all of you who patched in to be a part of this. This is the first in a series of alumni events like this that we'll be holding. So we'll have a chance to continue this conversation. I know that next up, we're developing plans for a program that will focus on issues of race and inequality in our current moment. So we will follow up with details of that once we pen down the date and all of the participants. But I thank you all so much for joining us, and look forward to seeing you again on these programs, but also in person when the circumstances allow. So thank you so much, everybody. Bye-bye.